The information provided on this podcast is not legal advice and is intended for the sole purpose of providing education and legal information. Laws change over time, and the information provided on this podcast may not be up to date. We make no warranty, express or implied, regarding the information provided by our team or our guests on this podcast. The information should not be construed as legal advice and does not create an attorney-client relationship with us or any of our guests on the podcast. If you would like to consult with an attorney, please call 1-800-VICTIMS. That's 1-800-842-8467 for attorney referral contact information. This podcast provides a platform for the exchange of ideas and information to help educate crime victims on their rights. Some content will include topics and materials that may involve descriptions of violence or assaults, which can be distressing to victims and survivors. It may also impact service providers experiencing vicarious trauma. Podcasting from the Victims of Crime Resource Center, this is Knowledge is Power, Victim to Survivor, a podcast series where we help crime victims understand their rights so they can go from victims to survivors. On this episode, we'll be discussing immigration. Hello, everyone. It's me again, your humble host, Nima Malavi from the Victim of Crime Resource Center. Today, it's my pleasure to welcome in Blake Nordahl into the podcast. Blake is a supervising attorney of the Immigration Law Clinic at McGeorge School of Law. On today's show, we'll be discussing victims' rights in the context of immigration. How are you doing today, Blake?
I'm good. Thank you so much for having me.
Well, thank you so much for coming on the show. Let's get right into it. I want to start by talking a little bit about the Violence Against Women's Act, or VAWA for short. Can you tell us a little bit about what the Violence Against Women's Act is and who does it protect?
Sure. So the Violence Against Women Act is a federal law that's been a law for over 20 years. And relevant to immigrants is it provides potentially a pathway to permanent resident status for undocumented folks who have been battered or subjected to extreme cruelty by a spouse who is a lawful permanent resident or a U.S. citizen.
And as far as the folks that it protects, are these protections only provided to women, or are they provided to men as well?
No, it's not just to women, although, of course, it's called the Violence Against Women Act. We have represented men in this application process before. But basically, the individual has to show that they've been battered or subjected to some sort of emotional abuse, that they are married to a lawful permanent resident or a U.S. citizen, that they have good moral character generally, that they're, at least at one point in time, were living with that relative, that U.S. citizen or permanent resident spouse here in the United States.
Now, you mentioned that the two criteria for qualifying are to be battered or to be subjected to extreme cruelty. Now, extreme cruelty kind of sounds like a broad term. Could you maybe provide just a little bit of information as far as what would constitute extreme cruelty?
Yeah, so there's no one thing that factor that is extreme cruelty, but what we want to do is when we're working with clients and we find somebody who does have potentially this situation, either, I've mentioned spouses, but there's also elder abuse. It might be that you were abused by an adult U.S. citizen child, for example. It also can be a child who's abused by a U.S. citizen or permanent resident parent. So just the majority of the time, though, there is a spousal relationship. And in terms of extreme cruelty, the factors that are listed by immigration include things like threats, harassment, social isolation. We frequently will see, well, if you call the police on me, I'm gonna get you deported. So we see this like the threat of holding the fact that the person is in a vulnerable situation because they are undocumented, using that against the individual. That's a frequent thing that we see in the clinic that I work at. Almost
as a form of coercion, it would seem like.
Yes.
And what are the steps for accessing these protections under VAWA if someone finds themselves in that position?
Yeah, so basically, in a normal or in a typical family-based immigration application, you have the U.S. citizen or the permanent resident relative files a petition with immigration that starts the process to obtain legal status. And what VAWA tries to do is allow the individual to go ahead and make that application, even though this abusive relative is not going to be doing that for them, and they don't need to stay in that relationship in order just to continue the process with immigration. So yeah, that first step is a self-petition. The individual files their own petition with USCIS that goes over the application requirements, some of which I've already mentioned earlier.
Okay, and just to clarify, so this would provide an independent path or an independent basis for citizenship ultimately.
Eventually, the individual could apply for citizenship. It's essentially, you could look at it as a three-part process. First, that self-petition, that identifying yourself as a survivor of domestic violence that meets the other requirements. Then potentially an application for permanent resident status, and then ultimately, eventually, an application for U.S. citizenship. That's right. But in addition to the requirements which we mentioned, including residence in the United States, good moral character, having resided with the abuser at some point in the past, and currently living in the United States. In addition to those requirements, there's also, we might call them speed bumps along the way, or potentially barriers to the application process. And so that's where you need to meet with a qualified immigration attorney to ensure not just that you meet the basic eligibility requirements, but that you also are not subject to a ground of inadmissibility or deportability that is going to not only prevent you from obtaining that status, but potentially place you into removal proceedings.
And just to be clear here, some of the grounds for deportability, could you maybe just give us an overview of what some of those could be?
Yeah, so it may be, the first one for a lot of individuals for VAWA, and this isn't actually a benefit, is being present in the United States without inspection. So the individual who came into the United States without permission, that's automatically waived under VAWA. However, most other grounds they're not automatically waived, and on top of that, they're somewhat difficult and require extra steps. So let's just even think about the individual who maybe has a deportation in their past and then has come back into the United States. So that somebody who's been deported and then comes back. Mm-hmm. Well, that individual is inadmissible not just for being present without inspection, but also having a deportation. And so they're going to be inadmissible. They're going to be subject to potentially being placed again into deportation proceedings. There is, and this gets a little bit complex, but there is a waiver even for that individual under VAWA. But they must show that deportation or that subsequent reentry was somehow connected to the abuse. And if they're not able to do that, then they're not going to get the waiver, and application would be denied. Other common form, and that's a very common issue that we see as somebody who's been deported or and then returned. You're looking at individuals who might have convictions for maybe drug use or crimes of moral turpitude, theft offenses, for example. And again, what we're looking at on those offenses is there somehow a link that we can show that the conviction or the ground of inadmissibility is related to the abuse?
I see. Fascinating. Now, those are obviously some very complex topics. If some of our listeners have more information, or if they would like to get more information about anything that we've discussed under VAWA, do you have any resources or can you recommend any ways in which folks can get some more information about any of these topics?
There's a few great organizations in the Sacramento area where we're located. So first of all, there's ourselves, the Immigration Clinic at McGeorge, and I can give that number. It's 916-340-6080. There's also a few other organizations that we work closely with and do excellent work, and that includes Opening Doors, CRLAF, and in general, there's an organization in Sacramento, kind of an umbrella organization known as the Fuel Network, which was created by the city of Sacramento about 2 years ago to help provide resources to folks who are undocumented or have no status and need assistance.
And for all of our listeners out there, we'll go ahead and provide all of the information for those organizations in the written portion in the text under where you can access the podcasts. Okay, thank you so much for that information, Blake. Let's move on and talk a little bit about U visas. Can you explain what a U visa is and how it can help an undocumented person?
Sure. There's a couple key differences between a U visa and the VAWA application we were just speaking about. So if you remember when we were talking about VAWA, there's a requirement that the perpetrator of the crime has some sort of family relationship to the applicant, plus that person had legal status, either that they were a U.S. citizen or permanent resident. Well, for the U visa, neither of those are required. A U visa is for survivors of crimes of violence who suffered substantial either physical or emotional harm and were willing and did cooperate with law enforcement in reasonable requests for assistance.
Okay, and just to make sure I understand, Blake, what qualifies as abuse under a U visa?
Yeah, it's an interesting question in terms of what qualifies as abuse. So what the regulations or the law states is that there's no one single factor that means that this is substantial abuse, right? And so they're looking at several factors, and in addition possibly to other factors that might not be on my list, but some of the things that you're looking at to see if the abuse was substantial was there a physical or emotional harm? I think that's abuse. And then whether it reaches the level of substantial, you're looking at, well, what was the nature of the injury? What was the duration of the conduct? What was the conduct on the part of the perpetrator? So, was the perpetrator's actions could have been severe even though the harm wasn't severe. So you're looking at the perpetrator's conduct, you're looking at the harm itself, the duration of the harm. So some examples might be if you're looking at somebody who is involved in a domestic abuse situation, there might be only one time, for example, that they called the police. And the time that they called the police, or that maybe even the neighbor called the police or a friend called the police, it doesn't need to be the applicant themselves that called the police, but it's not that we're looking at just that one isolated event where law enforcement was involved. The applicant who's applying for the U visa can describe the other incidents that happened through the course of that relationship, and you're looking at the totality of the circumstances that creates the substantial harm. You're also looking at the length of the injury. So if an emotional injury or psychological injury is that long-lasting in addition to physical injuries.
Okay. Now, as far as if our listeners believe that they might qualify for a U visa, what sort of steps would you recommend they take to actually start the process of acquiring one?
Well, again, just like under the VAWA process, they certainly need to be speaking with an immigration attorney before making any application. There was just this past year, the current Trump administration has issued a rule, which is that if an application is denied, so an affirmative application, like an application for VAWA or even for a U visa, that it could start the deportation process. So we haven't actually seen that started, but the policy has been implemented. We're waiting to see how it's going to be carried out at the local level. But in the past, that's a change from the past, where in the past, if you had an application that, as a survivor of a crime of violence, like a VAWA application or a U visa application, and the application was denied simply because maybe you didn't meet all of the required elements, that would not trigger the individual being placed into removal proceedings. But under the current guidelines, I believe as of this fall, the guidelines state that the individual could and will be placed into removal proceedings in that situation. But I do want to mention that at the local level, we haven't seen that carried out yet.
And that might speak to the importance of speaking to an attorney, someone qualified to, discuss these issues before one submits an application, I would assume.
Definitely. And before you're making any application with immigration at any time, you should always be speaking with a qualified individual, qualified attorney that practices immigration regularly. One of the things I was just going to mention, we've talked about, well, the individual has to show that they were willing to cooperate with law enforcement. So what does that mean? Well, what it ultimately means procedurally is that the local law enforcement agency, like the police department, sheriff's office, or the district attorney, is going to sign a certification that indicates that the individual was a victim of a qualifying crime and did suffer substantial harm and did cooperate with law enforcement.
So with respect to this certification, is that something that the survivor would ask the police to provide, or is that something that the police would do just as a matter of course?
No, we'll see it occasionally where, especially at the district attorney's office, the victim witness advocate will mention to somebody that they give them some resources of organizations that help immigrants when they see that the person has been a victim of a qualifying crime of violence. But for the most part, they're not going to be informed of these rights, and they're going to need to seek out assistance on their own. And it's the attorneys, like myself and others, that make that request with the law enforcement agency to sign the certified form, and that is one of the first elements or requirements of submitting that application for a U visa. Once the law enforcement agency signs it, then the individual has 6 months to submit their application with immigration. I was going to mention that, for example, the district attorney's office here in Sacramento County actually has information on their website about how to make the request for the U visa certification.
And just one thing I wanted to clarify, with respect to the difference between VAWA and the U visa, you mentioned with VAWA that as a requirement, there would need to be one of the spouses, the perpetrator or abuser spouse would need to be either a citizen or a lawful permanent resident. Is that the same requirement for a U visa, meaning if there were two, let's say, undocumented individuals and there were to be a violent action that would occur that would result in the substantial abuse standard, would that be a basis for someone qualifying potentially for a U visa?
Right. So you might find that the individual is eligible for a U visa, but not for VAWA. So, for example, in a domestic abuse type situation where the abuser is also undocumented, that individual may qualify for a U visa, whereas they would not qualify for a VAWA-based petition.
Interesting. Thank you for the explanation on that. So getting back to the certification process as we were discussing, can you give us an idea maybe of how long the process would take in general?
Sure. So California passed a law within the last couple of years that requires the certifying agencies to respond. I think it's within 90 days. So and we're seeing that happening here at the local level in Sacramento. But then that's just the beginning of the process. So once the individual has that certification from law enforcement, that means they can continue with the application, and assuming they're otherwise eligible, submit the application with immigration. Well, then what happens? Well, it takes years. So right now we're seeing that applications that we submitted maybe 4 years ago are finally getting adjudicated. And then when they're adjudicated, they actually don't receive the U visa. And we'll talk a little bit about what the U visa actually is. But a U visa is essentially it's a temporary visa. You can think of it like a student visa, a tourist visa. These are temporary visas. Well, U visa is also a temporary visa, but it has allows the individual, after they've been on the U visa for 3 years, to submit an application for a green card or permanent resident status. Congress only allows 10,000 U visas every year. So there's currently a backlog, a multi-year backlog, because of the number of people making these applications. So even once the application is looked at by an officer, we'll get a letter back saying, it looks like your application is good. We would like to approve it, but we don't have any visas available because of the backlog. So at that time, that individual is placed in what's called deferred action. And for those listeners who know about DACA, it's very similar to DACA. You get a work card, and you get some protection knowing that you're not a law enforcement priority for immigration purposes or for deportation purposes. So you'll get that work card, which will last until you're able to get the U visa because your place in the line comes forward. So yeah, it's taking about 4 years just to get that first step approved on the U visa, getting somebody to look at the application. And then once they've looked at it, they say, yes, it looks good, but we can't give you the U visa yet because there aren't any visas. And that's another couple years. And so throughout that process, we're looking at 6 years until somebody gets the U visa. Then once they're on the U visa for 3 years, they apply for a green card. It's almost like a lifelong process, right? So it takes a long time. And there's some hardship that is suffered by our clients in that process.
And I just want to pick up on one thing you mentioned. You mentioned that while an applicant is going through this process, that they're not a priority for law enforcement. Mm-hmm. Would that mean that they would not be subject to, let's say, removal proceedings, all things being equal, assuming that there's not been a crime that's committed or something like that?
Right. Assuming that they are not arrested for criminal conduct while they're in that deferred action status, then they will not be placed into removal proceedings. We've seen a few stories with the DACA folks, the young individuals, or not so young anymore, that have deferred action through the childhood arrival program that President Obama had started several years ago. There's been some arrests of those folks either by immigration for deportation when they might have a conviction for a DUI, or there's been some very isolated situations where somebody left the country without first obtaining advance approval. And there's been a few isolated reports of immigration believing that the individual was doing some other illegal activity, like a gang activity. But all things being equal, the person will not be placed into removal proceedings when they're under deferred action.
I see. Thank you for the explanation. Now, with respect to the U visa, how are family members of a survivor? How does the U visa sort of take them into account? Are they provided for under this process? Are they eligible for relief? Yeah.
So certain family members can be included as what we call derivatives on the application. Depends on the age of the principal applicant, but generally, so an applicant who's over 21 years, we're looking at their spouses and their children who are under 21 when the application was started. So remember, this is a multi-year application, so we're looking, the date that matters is the date that the application was filed with immigration. So if the main applicant was over 21 at that time and they were married, then they can include their spouse and their children under 21. What also is interesting and a beneficial fact is sometimes we can include what, I hate to use legal terms, so I'll just say, so let's say you get married while this U visa is pending, right? It's taking multi-years for this application to process. So there are ways, if the individual gets married while the application is pending, or even while they're under that U visa and waiting to apply for the green card, that we might be able to help their spouse, their new spouse, so to speak.
I see. And can you talk a little bit about some of the benefits of the U visa? Now, you mentioned it's a multi-year process. This could take, several years in a lot of cases. Are there benefits as far as maybe work permit-wise or access to social services?
Yeah, so for the U visa, once you receive the U visa, or once you receive that deferred action, you can apply for a work card. So that was 4 years after you submit the application, you might get deferred action, and that's ballpark or approximately. But that's when you may be able to obtain that work card. In terms of public benefits, there are public benefits available for individuals who are in the U status. So they may be able to apply for both federal and state benefits to assist them. and that won't harm them when they make an application in the future for permanent resident status. Because there's been a lot of information in the news about the current administration going after people that are under what's called the public charge. So low income individuals, or low income in particular immigrants. But for the U visa, if you have the U visa, you qualify for public benefits and you're eligible for them, and you should receive them if you need them, and they will not cause harm when you're making the application for the permanent resident status.
I see. And if there are folks out there who have some more questions about the U visa or are interested in maybe applying or learning more, are there any organizations available, any resources that you can maybe direct them to or recommend?
Yes, I would mention the same ones before ourselves at the Immigration Clinic. The Fuel Network, which if you Google Fuel Network, you'll see it. There's a list of organizations that are participating, including ourselves. Also, then I would include Opening Doors as an excellent organization in Sacramento. And then the California Rural Legal Assistance Foundation, or CRLAF as they're known. In the Bay Area, there's also several other organizations, including Centro Legal is a great first place to look, as they're an umbrella organization.
And once again, to all of our listeners, we'll provide the information, the links to reach out and contact the Fuel Network, Opening Doors, CRLAF, and Centro Legal in the episode description. That's all the time we have for today's episode. Please join us on our next episode for part 2 of the discussion. Thanks for listening.